Guess who's back? Back again. Uncivil's back. Tell a friend. Guess who's back? 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 Nah, 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 nah. Hello, everyone. Welcome to Uncivil Law, Batch Record Part 2. We're only going to record one story now. We're going to record the Jennifer Shah story, which we'll probably edit and we might release tomorrow. But, we might as well film it live because it gives me some pleasure and some enjoyment. And some of you might enjoy it too. Noti says, oh my God, clip that lols. I'm here for the lols. I'm here to have some fun. I'm here to have fun until someone clips me and makes fun of me, and then we don't have any more fun for a while. So don't be that guy. Oh, man. I'm going to give a second for people to join. Give a second for people to join the live stream. Everyone grooving tonight? Everyone feeling good? My batch record did get copyright claimed by Scissor Sisters. So if we're going to use it as the theme song for the channel, we're going to have to get someone to do a cover, so it won't get flagged by the bot. Epic ringtone. Smacking that like button. You smack away, ma'am. You smack away. All right, so let me tell you the story we'll be covering, and then we'll cover it, okay? So we are covering United States of America versus Jennifer Shah. We recently covered this in terms of the... Oh, I need something. I need to hold this. 1 second. Sorry, I forgot something very important. Anyways, we're covering United States of America versus Jennifer Shah. We recently covered the motion from Shah to have her Miranda thing dismissed. We laughed. We laughed hard. And now the United States Attorney would like to join us in laughing. So we're going to do that together. I'm wearing basketball shorts. Basketball shorts are tight. So very comfortable. All right, so let me get ahead and get this started. Is this the real life? Is this just fantasy? Caught in a landslide, escape from reality. Open your mind, look up to the sky and see. I'm just a poor boy, nobody loves me 'cause it's easy come, easy go. Little high, little low, anywhere the wind blows doesn't really matter to me, Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and I hope today will be the day that I earn your subscription. For today's story, we're doing a follow-up in United States of America versus Jennifer Shah. Jennifer Shah is a star on the show, The Real Housewives of Salt Lake. Unfortunately, she also has become a star with the United States Attorney, who is accusing her of being part of a telemarketing enterprise scheme that is engaged in fraud and all sorts of fun stuff. Recently, we covered when Jennifer Shah wanted her her confession to be thrown out. And now we're going to cover the United States Attorney's reply. But before, of course, we get to the reply, we have to discuss what she's being charged with. So in this reply, the United States Attorney will cover what she's being charged with, cover some law, and then we'll get to the Miranda part of this case. Let's get started with this. On March the 25th of 2021, a grand jury sitting in this district, which is the Southern District of New York in this particular case, returned a superseding indictment, the indictment, which was filed under seal, charging the defendant, Ms. Shah, and co-defendant, Stuart Smith, with carrying out a wide-ranging telemarketing scheme that defrauded hundreds of victims throughout the United States, many of whom were over the age of 55, by selling those victims so-called business services in connection with the victim's purported online business and for participating in a related money laundering conspiracy. So, yeah, we're definitely charging the Real Housewife with some fairly serious things. A telemarketing scheme to defraud seniors and selling them services that they don't need and aren't really real, and participating in money laundering. So, the United States Attorney is out for blood. They're not kidding around. What exactly did the defendants do? Let's learn a little bit more. The U.S. government argues this is basically the crime charged. The defendant, in order to perpetrate the business opportunity scheme that was identified in the indictment, the telemarketing companies, also identified in the indictment, used a list of potential victims, or lead lists. The lead lists were fueled by the business opportunity scheme, were first created when individuals who were victimized by the scheme made a small online purchase, typically less than $100, in response to an ad offering work from home or other online business opportunities. Okay, so we've got a multiple part scheme. We're going to see who the suckers are by giving them to give us a relatively small amount of money. We're going to say, hey, work from home. In order to work from home, give us $100. If those two things don't sound like they go together, you're smarter than these victims. And then they said, hey, wait a second, if they fell for that, what else might they fall for? Right? So this small fraud was used as a lead list for bigger frauds. How exciting. Once the victim made the initial purchase, the victim's information was provided to an online education or coaching company, which historically was Thrive Learning or Guidance Interactive. Beginning in and around 2012, the defendant worked at Thrive. That would be Shah, right? She worked there, which later became Guidance, and was responsible for selling the leads. That is, the information on the victims who made these sub 100 purchases to downstream sales floors. So she got the lists, and she would sell them to other people committing frauds who could take advantage of this. That's the allegation. Leads typically flowed from the defendant to coaching floors operating in Arizona, Nevada, or Utah, such as telemarketing companies operated by co-defendant Kevin Harden and Cameron Brewster, who sold the victims coaching sessions. During those sessions, the victims would have phone calls with a coach, who the victim understood would teach the victim how to operate a successful business, but in fact, operated to prime the victim on additional services the victim would ostensibly need in order to be their business successful, right? So the coach said, well, here's some things that you can get to get your business successful that you need to buy from us. The coaching floor then passed the victim's information to a biz-op telemarketing company, such as the telemarketing companies operated by, among others, the co-defendant Anthony Chidi, or defendants in a different case, such as William Sinclair and Ryan Holt, which then proceeded to sell victims services that the victims had been instructed by their coach to buy, including tax services, corporate credit, and business plans, all of which are of little to no value. So the plan here was that we're going to see who's the sucker at buying these relatively small. You want to work from home, give us $100, and you can work from home. Now, one wonders why they're not paying you, but you're not supposed to ask that question. And apparently a lot of people did ask that question. So then we have a set of leads. And Miss Shah over here is part of the conspiracy. She is taking these lists and she is selling them to other people who are engaging in these schemes to defraud people by selling them things that are of no real value to the elderly and so forth, and people who are taken advantage of. That's what the U.S. government thinks happened. But we need to know a little bit more about what the defendant specifically did. Okay, let's learn a little bit more about what Jennifer Shah specifically did. The defendant, that would be Jennifer Shah, controlled her streams of leads from start to finish. The defendant obtained the initial lead after the sub $100 purchase and determined which coaching floor could buy leads from her and Smith, selected the downstream sales floors to which the coaching floor was permitted to pass leads, chose the firms to provide fulfillment, which sometimes involves selling a firm operated directly by the defendant herself. So sometimes the firm that would provide fulfillment was Shah. Okay. Set limits on how much the downstream floors could charge and determine which products each of the downstream floors could sell. Sounds like she had a lot of control in this operation. And she's not just merely a pass-through, she's a manager. Yeah. Unless the coaching floor purchased leads outright and therefore could decide whether and how to sell them to downstream floors, typically when a sales floor sold additional services to victim, the sales floor paid a percentage of the revenue from sale to defendant. So it's a pyramid scheme on top of everything else, or at least a kickback, right? So depending on how successful the downstream people were on selling the victims on these useless services, Miss Shah would get a direct cut as a kickback or as a vig, to use a little bit mafioso language, right? Yeah, so that's a lot of incentive to pick exactly the right people who can exploit those people to the maximum. Got to get that vig, man. Shah, not Shah, you're right. From approximately 2012 to 2013, the defendant provided leads to Top Shelf Marketing, great name, a marketing floor in which Holt and his co-defendant, Jason Sager, operated in exchange for a revenue share. So they're also getting, portions of the business. From approximately 2013 to 14, the defendant provided leads to reliable business consultants who, maybe not so reliable, a sales floor also run by Holt. He runs a couple floors, as well as some other people in New Jersey. In approximately 2014, the defendant provided leads, in part through Holt, to Olive Branch Marketing, a sales floor run by Sinclair, and co-defendant Michael Fioricero in New Jersey. From approximately 2013 to 2019, the defendant, that'd be Miss Shah, provided leads to coaching floors operated by Herndon, who passed them along to biz op floors, including Corporate Development Center and Alliance Education Services, the New Jersey-based sales floor in the indictment. So, yeah, Ms. Shah over here is involved in a pretty deep conspiracy to tell the U.S. government, telling the tale. She is getting these leads, and she personally is determining who gets these leads. Which of them will get it, and she gets a kickback, and other people get kickbacks in selling these services. So all you really need to prove at this point is that she knew it was fraudulent, right? that she knew that this was all like a scheme. And this all was fake. But, so you have to really show her knowledge. But other than that, you got her pretty deep in a conspiracy to commit fraud. She's not just a pass-through. She's a manager. She's selecting which businesses and which of her favorite people will get these lucrative leads for the business services that don't really exist. How great. How wonderful. Zulu Zet says, let the market sort itself out. They can initiate a lawsuit quagmire after the damage is done. Well, we believe in free business, but we also believe in fair business. You have to actually engage in fair and honest dealings. It's a basic principle of contract law. You can't be fraudulent in your services. You have to provide what you're saying you're providing, and they actually have to have value. So, this is not a lawful enterprise, according to the government. This is a fraudulent scheme. They are specifically picking people who are vulnerable to specifically target them in order to buy things that they know are going to be worthless to those people. That is not fair and honest dealings. That sounds like a corrupt enterprise. So, short of the super libertarians who go with the full caveat emptor, short of the super libertarians, most, even conservatives, are going to look at this and be like, yeah, no, we have to have honest dealings and fair trade. This is not going to fly. The indictment specifies the time period of the conspiracy as between 2012 and March of 2021. It goes on to allege that the object of the conspiracy was to commit wire fraud in connections with telemarketing, which victimized 10 or more persons over the age of 55. The indictment provides additional details of wire fraud's object, explaining to the defendants willfully and knowingly having devised and intended to devise a scheme and artifice to defraud, and for obtaining money and property by means of false and fraudulent pretenses, representations, and promises, would and did transmit and cause to be transmitted by means of a wire in interstate and foreign commerce, writings, signs, signals, pictures, and sound for the purposes of executing the scheme. So, to translate that a little bit more into colloquial English, what they're saying is that these people knew they were committing a fraud. It was their intention to commit the fraud. And with that intention in mind, they used interstate communications, a wire, which is to say telephone, in this case, because it's telemarketing, right? That would be the wire. They used the wire in interstate commerce, because they're calling between different states, in order to transmit, signals, in this case, their voice, for the purpose of executing the scheme. So with the intent to provide false and fraudulent pretense, they knew that they were committing false pretenses. They knowingly did that. They used a telephone in order to communicate the fraudulent pretense in order to obtain money. That's basically what that says in a slightly more colloquial English. The indictment here states, among other things, the defendants and her co-conspirators fraudulently induced and caused victims, many of whom were over the age of 55, to pay thousands of dollars to obtain so-called coaching and business services, which they represent would make the management of victims' purported online business more efficient and or profitable, when in actuality, the services would provide little to no value to the victims, to the businesses, because those businesses were non-existent. So they're selling them services for a business that doesn't yet exist. How much tax service do you need when you don't have a business that's bringing tax revenue, right? These facts, among others stated in the indictment, provide ample basis for inference that false pretenses, representations, or promises used in the course of the conspiracy were material to the victims. And material here means that the victims in some sense relied on them. Like, it's not like they didn't care about it one way or another. That based on what they said, that it made a difference. That's what it means by material. At the bottom, this aspect of scheme was simple. A classic fraud. The use of false pretenses, representations, or promises to induce victims to spend thousands of dollars on services that were of virtually no value to a business that existed, if it existed at all, only on paper. Of course, those false pretenses, representations, or promises were material, because a reasonable person would not spend thousands of dollars on a service that they are forthrightly told have no value for a business they are candidly advised does not actually exist. So, that's exactly the issue here, right? That we're committing these false pretenses, right? You need this for your business. In some cases, the businesses didn't exist at all. In other cases, the businesses only existed on paper. So maybe it's like, an LLC filing or somewhere, right? So it existed, but only on paper. And you're selling these really expensive services to people don't need them. And you're telling them that they need them, which they don't. And as a matter of fact, they don't need them. And you're doing this to people who are particularly vulnerable, over the age of 55, which are protected. So yeah, because no person who's rational would choose to do this because they're told the services have no value, but they're convinced to buy them anyway. So yeah, a little bit of fraud there. Yes, I did need to make an announcement. Thank you, Stephanie, for reminding me. Tomorrow at 8 p.m. Central, 9 Eastern, we will be recording in a live-to-tape, like we're doing now. We'll record in a live-to-tape episode of Gun Talk with Stephanie, who will be joining me. We will release it. So what we'll do is we'll film it live, and then we'll immediately remove it from the channel. We'll edit it, and then we'll release it for real on Friday. Because we're going to try to do a Gun Talk Friday. We'll try to make it a theme. So yeah, that's what we're doing. So tomorrow, and I'll make the announcement on my channel after this video is down. I'll make it on my channel. But just a reminder for everyone who's here, 8 p.m. Central, 9 Eastern, Gun Talk with Stephanie. Should be fun. We've got quite a couple stories already lined up. Should be fun. Yeah, it's not Gun Friday. It's Firearm Friday. Firearm Friday with the Texan. Okay. So, with this background as to what the crime is, this criminal conspiracy to defraud the elderly and take money from them, now the U.S. government has to respond to the Miranda waiver request. Because you may remember Ms. Shah said, I want those confessions thrown out of court. I didn't waive Miranda voluntarily. Okay. So the U.S. government has some thoughts about whether that was voluntary or not. Let's give what the U.S. government has to say a shot. The defendant moves to suppress her post-arrest statement on the ground. She purportedly did not waive her Miranda rights. Oh, thank you, John Day, very much for the $20 super chat. That's very, very generous of you. Thank you. Can you do a video on Turner versus Driver? Okay, I will make a note of it in my Discord. Hold on. I think it's been a while since I've had a paid story. Thank you. I will cover that. Let's see, where was I? The defendant moves to suppress her post-arrest statement on the ground she purportedly did not waive her Miranda rights. Her challenge is baseless and should be rejected without holding a hearing. I agree with the U.S. Attorney. It's pretty baseless. Detective Bastos drove the defendant to ICE headquarters. Upon arrival, the agents brought the defendant into a break room and handcuffed her to a chair. Detective Bastos turned on a recording device and introduced himself and Special Agent Kathleen Colbert. He showed the defendant the Statement of Rights form and advised her he would read it verbatim to her. Before reading it, however, Detective Bastos asked the defendant the following questions. So this whole thing is being taped, incidentally. So we have exact quotes, right? So they, 30 seconds into the interview, right, they start with some very preliminary questions before reading Miranda. And these preliminary questions are all fine without Miranda because there's nothing potentially incriminating here. These are just real basic questions, right? Just identity questions. So the detective asks, how do you pronounce your name? Jennifer Shah. Jennifer Shah, what's your date of birth? She gives her date of birth. Okay, and you live where? In Park City. Is that the Paloma address? Yes. What address? This address, right? So that is, that's from 32 seconds to 49 seconds in the video. What is your name? What is your date of birth? Where do you live? Right? That's what we got. All right. So then, after that brief introduction, because first he introduced himself and he introduced the other special agent in the room, and then he asked these preliminary questions, which are fine to ask without Miranda, and then he read her rights, and she initialed next to them each on Miranda. After reviewing the defense rights, Detective Bastos read aloud from the waiver form. He's reading this aloud. We have it on tape. I have read, or someone has read to me, this statement on my rights, and I, meaning you, understand where my rights are, and at this time I'm willing to answer questions without my lawyer present. Is that correct? Defendant replied yes, and then signed the form. The defendant then mentioned that her contacts were blurry. Special Agent Colbert asked, "Are you okay? Do you need to go to the bathroom?" The defendant spent the next several minutes fixing her contact lenses with the assistance of Detective Bastos and Special Agent Colbert. When your eyes are feeling particularly dry, you really need to get that dry feeling out. And for that, may I recommend Visine for needing to get that redness out of your eyes and give your eyes that lubrication it so desperately desires. Visine eye drops for that time when you need to read your Miranda warning card. Before we move on, it might be fun to actually look at the Miranda card itself that she signed, so we can see at least what one looks like when it's prepared. Before we move on, it would be helpful for us to look at what a Miranda card looks like. So let's look at the one that ICE prepared and that she signed, the actual Miranda card that she was presented with. We can see it. It was attached as an exhibit. Let's look at it together. Okay, here's what ICE's Miranda card looks like. All right, and you can see, here's what it says. Before we ask you any questions, it is my duty to advise you of your rights. You have the right to remain silent. She initials next to it. Anything you say can be used against you in a court of law or other proceedings. Initial next to it. You have the right to consult an attorney before making any statement or answering any questions. Initialed. You have the right to have an attorney present with you during questioning. Initialed. If you decide to answer questions now, you still have the right to stop questioning at any time or to stop the questioning for the purposes of consulting an attorney. Initialed. Right? So she's read all these rights. She's read them. The detective reads them all. And she initials all of them. And this one she missed, so he reread that line. right? Because we know that from the tape. And then she's asked to sign at the bottom. Waiver, I have read, or someone has read to me, this statement of my rights, and I understand what my rights are. At this time, I'm willing to answer questions without a lawyer. She prints her name, which she's apparently able to do, on the right line, and signs it, and date it. And then we've got the witnesses, the detectives saying, yeah, we saw her do that. So, yeah, looks okay to me. A little over 30 minutes into the interrogation, the detective and defendant had the following exchange. The detective, okay, so let me ask you some questions. Did you know anybody who's been arrested in BizOp within the past 5 years? Arrested? Like charged federally? You've been arrested federally? Do you know anyone who's arrested for working in the BizOp industry? Well, I heard from people that there were some people arrested. I don't know what's his name. I didn't know a lot of them. It seems to be like from Jersey. I didn't know them. Which, given how involved she was, apparently, there's a lot of skepticism there. Okay, so now that we know the factual background, including her need for eyes drops, we need to discuss the law. What is the law when it comes to Miranda? What does the government have to do? What can they do? What can't they do? Well, let's read a little bit about the law as it applies to this situation. To prove a valid waiver of Miranda, the government must establish by preponderance of evidence that the relinquishment of rights was voluntary, in the sense it was the product of a free and deliberate choice rather than intimidation, coercion, or deception, and that it was made with the requisite level of comprehension, that is, a full awareness of both the nature of the right being abandoned and the consequences of the decision to abandon it. She was told her statements could be used against her in a court of law or other proceedings, so, she understands the consequences, yeah. A statement will be deemed voluntary unless it results from circumstances that overbear the defendant's will at the time it's given. In Colorado versus Conley, the Supreme Court held a confession is involuntary only when it results from police coercion. This is because the sole concern of the Fifth Amendment, on which Miranda is based, is coercion. The Fifth Amendment privilege is not concerned with moral and psychological pressures to confess, emanating from sources other than official coercion. Yeah, there might be a lot of reasons that you might want to confess, not the least of which is your own sense of guilt, which, the urge to confess, they say, is a detective's best friend. So, yeah, you might have a lot of reasons that you might want to confess. Those might be moral, those might be psychological, they might be whatever, and the government is allowed to play on those interests. They're allowed to play on them and say, you have this interest, don't you want to exercise on it? That kind of thing, right? They just can't deceive you. They can't coerce you, but they can, put psychological and moral pressure on you. A good person would tell us the truth. Yeah, you can ignore them because you have a free will, so yeah. Your dry eyes coerced you? I don't think that's how it works, Stephanie. As a result, while mental condition is surely relevant to an individual's susceptibility to police coercion, mere examination of confessant's state of mind can never be conclusive to the due process inquiry. It is well settled that coercive police activity is necessary. So the defendant's mental state is irrelevant unless the police are doing something, a thing, to be coercive. If you are just particularly the kind of person who likes to confess everything, the police love to hear it. They can't be taken fault of for taking advantage of your willingness to tell them all the things. All the people who involved in the Capitol riots who have shared the slideshow with the FBI, for example. I'm not sure why you made that decision, but the government's going to let you make that decision. So, yeah. D. Patterson, who are you going to believe, me or your drying eyes? Bonus point. Bonus point. If you want a different story covered, if that story's already been covered, if you need a different story covered, I'm happy to cover something else. Because I don't, if you're super chatting me to cover a story and we've already covered it, I'd be happy to cover something else. Invoking the DE exemption has a narrow application, and this one is borderline. What is the DE exemption? What is the DE exemption? Bueller? Dry eye? Well, I'm not sure how I was supposed to conclude. DE stood for dry eye. But, okay. Following Connolly, the Second Circuit has recognized a defendant's mental state does not become part of the calculus for suppression of evidence unless there's an allegation the agent's engaged in some type of coercion. The inquiry into voluntariness is objective. It asks whether, based on totality of the circumstances, the government agent's conduct was such as to overbear a defendant's will to resist and bring about confessions not freely determined. Factors relevant to this determination include the characteristics of the accused, the conditions of the interrogation, and the conduct of the law enforcement officials. The defendant has failed to identify any undue coercion or pressure on the part of the agents, and therefore the court should deny the motion to suppress. At its core, the defendant's allegation is that the agents did not tell her about the charges against her until after the interrogation had ended. Yet the Supreme Court has expressly declined to hold that mere silence by law enforcement officials as to the subject matter of an interrogation is trickery that is sufficient to invalidate a suspect's waiver of Miranda. So, when the detectives don't answer your question and just sit there silently, that's not deception. Right? You're allowed to take note that they're not answering your questions. And you could say, if you want, I'm not answering your questions unless you answer mine. And if they still refuse to answer your questions, say, I'm invoking my right to remain silent. Interview's over. They're probably not going to answer your questions, incidentally. But if you want to, you can say, okay, you could ask them a question. They say, we're asking the questions. You could say, you answer my question, or I don't answer yours. Say, okay, and then I just say, I remain silent. Or what's even a better idea than all that? What's even a better idea? Just remaining silent in the first place. Here is the answer to every single question during a custodial interview. I will give you the answer to every single question, other than name, birth date, and address, which you can answer. That's okay. Okay? Other than that, here is the answer to every single interview question. You get to pick one of two phrases, and you can alternate between them. One of two. I want a lawyer. I wish to remain silent. I wish to remain silent. I want a lawyer. It doesn't have to be any more complicated than that. It's clear, direct, unambiguous request. I want a lawyer. I wish to remain silent. All you need to say. Don't say anything else. And you'll be fine. The defendant attempts to circumvent this clear precedent by claiming that when the detective said he just wanted to talk to her, he misled her into believing that law enforcement was just trying to clear up an issue, if not try to help her. Yeah, this is the part where I thought was pretty hilarious, where the attorney was trying to get the word just to do what we call yeoman's work, right? Trying to make this thing go beyond any distance. Herculean effort. The word just here is doing so much. It was a nice try, but no. This argument rests on a strained and illogical interpretation of the defendant's own affidavit, which the court should reject. When the agents arrived to meet the defendant, the first thing they did was place her in handcuffs and told her they had a warrant for her arrest. That's kind of a clue. When they put you in handcuffs and say we have a warrant for your arrest, kind of a clue. These actions were not designed to lull the defendant into a mistaken impression about the agent's intentions. Seems pretty clear to me. Seems pretty clear. Detective Bastos made clear from the outset defendants were being taken into custody pursuant to an arrest warrant. By later saying he just wanted to talk, Detective Bastos did not revoke his statement about her being arrested or otherwise misrepresent the situation. The defendant acknowledges at all points she remained in handcuffs, apparently arrested. She was handcuffed. She was put in the car. She was handcuffed to the table in the interrogation room. These were clues. These were clues. Not a lot of ambiguity here. Thus, Detective Bastos' words to the effect of, "I promise you we just want to talk to you," were not meant to, and logically could not, mislead the defendant in believing the agent's only purpose was to speak with her. You know, they read you the Miranda card. They put you in handcuffs. As they were reading you the Miranda card, you were in handcuffs. You know, not sure you're being misled here, Miss Shah. Kind of think that they're telling you exactly what's happening. Yeah. This is obvious from the interrogation itself. The defendant was handcuffed to a chair during interrogation. I think it might have been the table rather than the chair. But either way. Detective Bastos gave defendant a Miranda warning before asking any questions. These actions could only reinforce the detective's earlier statement that she had a warrant for the arrest. Yeah. Detective Bastos reminded her she had been federally arrested, which had elicited no surprised reaction. Detective also repeatedly expressed his belief defendant was involved in an industry rife with fraud. Even assuming the agent's actions could be characterized as coercive, which they're not, and I 100% agree. I mean, this is not anything even remotely close to coercive. This is, better or worse, standard operating procedure. This is textbook. This is textbook clean. You could use this as training material, is how clean this is. You know, you arrested them, put them in handcuffs. You told them you had a warrant for their arrest. You put them into a car, drove them. You put them into a room. You handcuffed them. You introduced yourself and the other person. You read them the Miranda card. You know, this is textbook. This is training material. Yeah. The totality of circumstances, including defendant's personal characteristics, and the conditions of interrogation all point to the same conclusion. The defendant's written waiver of her Fifth Amendment was voluntary. The defendant is 47-year-old reality television star and businesswoman, clearly equipped with sufficient mental acuity, which I guess in some legal sense has to be true, but yeah. And experience to decide whether to sign a Miranda waiver after being advised of the consequences of speaking with the agents, even taking into account her lack of prior interactions with the criminal justice system. Yeah, you're competent legally, so yeah. First, as the defendant acknowledges, her blurry contact lenses had no bearing on her ability to hear the Miranda warnings Detective Bastos read. For those times when your eyes are so dry that your ears cannot hear, we recommend Visine. Visine eye drops, used to get the red out for dry, itchy eyes, accept no substitutes other than Visine. The defendant also claims that she had a belief that she had been misidentified. Indeed, prior to signing the waiver, the defendant identified herself by name, date of birth, and address, so it's implausible she would give up her rights to clear up a misidentification when the agents had confirmed her identity. So she thought there had been a misidentification. At the very start of the interview, at the very start, it was before the Miranda warning, they asked name, date of birth, address. So, I don't think they're confused as that they have the wrong person. I think they think they have the right person. So, not sure why you signed the Miranda card to clear up the confusion when, they know exactly who you are. So, yeah. Similarly, the conditions of the interrogation in no way pressured the defendant to waive her rights. The defendant claims no unusual delay between her arrest and interrogation or other deprivations meant to wear her down. Yeah. The setting, the agent's break room, was not designed to intimidate. It's a break room. It looks like a break room. She was minimally restrained, but, handcuffs, which the agent told her was due to policy. There were only 2 agents present at the interrogation, which lasted approximately 90 minutes. Finally, as previously noted, the agents took care to address the defendant's physical discomfort by helping her fix her contact lenses. Unclear if it was Visine or not, but she got the dry out one way or another. Need to work on the ad spot? Was my ad spot not good enough? Oh no. Do I need to do better? Do you have dry, itchy eyes? Try Visine. Visine. For the dry, itchy eyes your eyes craves. When you need to read that Miranda waiver, get Visine to help get the red out. Is that better? Do you have dry, itchy eyes? Have you tried Visine? Visine is the all-new eye drop that helps you get that itchy redness out of your eyes in lickety-split time so you can be sure to read that Miranda card. Visine eye drops, accept no substitutes. I was lost in a desert with dry, itchy eyes. So lost, looking for an oasis. And then I saw it. Visine. Visine. To get out dryness, even a desert cannot remove. Visine to get the red out. Thus, that brings us to the end of the current discussion of United States of America versus Shah. In this case, Miss Shah asked for suppression of her statement she gave. And the United States government goes through a brief recitation of the things she's been charged with. She is apparently neck deep involved in a criminal conspiracy to defraud the elderly on telemarketing. She is making misrepresentations and cheating people out thousands of dollars. And the United States government is displeased. And as part of this, they arrested her with an arrest warrant. And they handcuffed her and gave her a Miranda card. And she says, but blurry eyes, though. And the court's like, the Miranda warning, you're able to hear it, right? So you're good. So, yeah, that's all that there is for today. And that brings us to the end of the discussion of this story. Move over Jeffree Star. There's a new star rising. Word. Here at Uncivil Law, we recommend only the best quality eye drops. Because I, as a lawyer, have to read lots of documents and look at the computer screen for long periods of time. So I know all too well what the sensation of dry, itchy eyes feels like when your eyes are so tired. And for those days when nothing else will do, there is Visine. Visine, the eye drop recommended by Uncivil Law. It helps this lawyer's eyes read. It will help your eyes read too. Visine, except no substitutes. It's the all-new eye drop. Yeah, it's the all-new eye drop. Yeah, I'll do it in that style, right? For that kind of voiceover. Have you heard about the all-new eye drop? It's Visine. Visine is the all-new eye drop to help you get out those red, itchy eyes. Visine helps on those days when your eyes are dry and itchy and just need the extra comfort that only Visine knows how to provide. Visine eye drops, except no substitutes. Do-do-do-do-do-do, ching! That was way too much fun. Way too much fun. All right, so I will edit that, and that will probably be up on the channel. Probably not tomorrow, probably Wednesday, but soon. Danielle says, did I just walk in on product placement? Oh, man, if only. Yeah, we'll put this as part of my sizzle reel. We can deliver the ad spot in any number of ways. Zulu Zet says there's no product of any kind which I want more than Visine right now. Respect. Yeah, so we'll edit this and we'll probably put it up on Wednesday. And then tomorrow night, 9 Eastern, 8 Central, Me and Stephanie are going to do some firearm stuff, live to tape, and then we'll edit it and we'll put it out for Friday, but we're going to record it tomorrow. So we'll post. Okay, so our new normal release time is 6:30 p.m. every day. I'm thinking about moving the live stream from Tuesday to Thursday because Emily's already doing Tuesdays, and maybe there's a competition problem there, but I'm not going to change it right now. I'm going to stick with Tuesday for right now, but I'm thinking about changing it to Thursday. But we'll give Tuesday a couple weeks to try, and then we'll move it to Thursday. But anyway, so 6:30 every day, 6:30 p.m. Central, we release a story. 6 days a week, right? Today's story I released an hour early because time zones confused me. So Saturdays I released at 5:30 instead of 6:30 because time zones confused me. But yeah, 6:30 Eastern time or 6:30 Central time, 6 days a week we release. On Tuesdays is our live stream day, so we'll do that, and then Friday, so we'll release a normal story tomorrow at 6:30, and then we'll film tomorrow at 8 for release on Friday. That sounds like fun. So, good times. Yeah. All right, I'm going to sign off now. I've enjoyed this fun time. I hope you've enjoyed the fun time too. So all the good stuff. I am going to sign off. I've been Uncivil Law as always. This video will be... Should I make it private or should I make it unlisted? I guess technically it's technically a 1-episode batch record. So I guess technically it's going to be private. So yeah, but you'll see it again soon enough. So yeah, we will see what's happening. Until later, my friends, I hope all is well. Cheers and goodbye.